Okay. Ladies and gentlemen and friends, Professor Shad, Faruqi, Aiza, and Sohana, we are indeed privileged today to listen to Emeritus Professor Shad Saleem Faruqi, who is holder of the chair of Tun Hussein Onn. And we're very happy to have you, Professor, today. And Prof is going to speak on the topic of the Constitution, the laws, and the public service. These are very important elements of our daily life. And we have very distinguished personalities to speak today. Professor Shad is Emeritus Professor of, I think, University of Malaya. And also, he was once a lecturer in law, in University Technology Mara, so he was very distinguished and very notable person. I don't think he needs further introduction. My name is Sulaiman. I'm a board member of ISIS, and with me is Iza, who will help me moderate the session. So without further ado, let me invite Professor Shad to make his presentation, maybe about 40 minutes, 45 minutes or so, after which we can have some question and answer. Prof, the floor is yours.
Thank you so much. Thank you so much, Yang Bahagia Tan Sri Sulaiman Mahbub, Puan Sohana, MS Iza Khairina, and distinguished participants. It's my honor to be with you. The topic is very broad. I will confine myself to some issues of reform. My aim is not to look at structures and forms, but functioning. Not just at theory, but at practice, not just at what is, but what ought to be. Let me begin by saying that the public services are the backbone of the government, and therefore our constitution and laws provide many provisions for the organization, characteristics, control, accountability, service conditions, and substantive and procedural safeguards for public servants. Next slide. However, there is no dearth of issues, challenges, and problems in the public services. May I now go on to slide number 6. I'm skipping a few. The characteristics of the public services in Malaysia. A common point of law is that all service is at the pleasure of the Yang di-Pertuan or the ruler or the governor. That's Article 132, Clause 2A. Next. The meaning of this is that all posts or any posts may be abolished. A ministry or service may be closed down or privatized. Parliament may refuse to allocate funds. And if there are no funds, then there are no salaries. Terms of service may be altered by the government unilaterally. In the private sector, terms of service are contractual. In the public service, things are slightly different. The government can act unilaterally. It can add additional language or training requirements for promotion or continuation of service. Next one, there is no security of tenure in the public services as far as the law is concerned. A person can be dismissed. In practice, however, it is not easy to remove a public servant who has become tatap. Tan Sri will, I'm sure, agree with that. However, let me just point out that in some countries, appointments are never permanent. They are on contract. So once the contract period comes to an end, you seek renewal or you leave. But in Malaysia, since the British days, we have had the situation of people becoming permanent and even eligible for pension. However, I have to point out to you, there is no absolute right to pension, as many civil servants wrongly believe. Actually, pension can be withheld or can be reduced by the Yang di-Pertuan, depending on the performance of the civil servant. Now, next point is a little bit controversial. Hierarchies. Appointments are to grades that the critics say are organized into colonial type of categories and groups, reflecting an unjust hierarchy. Now, I know this is controversial. There are wide disparities in take-home pay and emoluments between the top and the bottom grades. The disparities are accentuated because top civil servants are either required by the law or allowed to sit on the boards of statutory bodies, government-linked companies, or quangos, quasi-national government organizations, and they receive emoluments from them, which basically means that on top of their basic pay plus allowances, they also have the allowances from these quangos, etc. And while I cannot say this with certainty, I've been told that top civil servants in MOF can take back home as much as 200,000. Now, I do not know how correct that is, but if you are on the board of 10 statutory bodies, and from each statutory body you get about 5,000 to 6,000 ringgit per month allowance only, that's a fair amount of money. And then of course statutory bodies float companies, companies float subsidiaries, and I think top civil servants often have a role in some of these. So I may be overgeneralizing, but I've been informed by top civil servants that actually there is massive disparity. I understand, Tan Sri, that the minimum wage in the public service is about 1,200. So on the one hand, there is a human being who gets 1,002 minimum, then there are other human beings who get much, much larger. So I think there is a problem of wide disparities in take-home pay. This wide disparities also create a problem of conflict of interest in the sense that though the top civil servants on statutory bodies will provide some control and direction, at the same time, there is also a problem of conflict of interest. So if someone from the ministry is on the board of a university, he of course wants to encourage compliance with ministry's directives. At the same time, the university wants to break free. The university wants to act with dynamism. The university is a separate statutory body. So where does this top civil servant's loyalty lie? Does it lie with the university's desire for flying as high as its wings can take it? Or is the civil servant's loyalty with his ministry? There is also a problem of delay, Tan Sri. Quite often, and I've seen this from personal experience. We want to have a Jabatan Kuasa Tata Tertib on which, let us say, the DG is a member. So we call him up and say, very serious case actually, a sexual harassment, immediate action is needed. When can we convene? He looks through his diary and he says he's free only next month. So in the meantime, actually, a serious Tata Tertib case is held over because the Jawatan Kuasa Tata Tertib cannot be convened because the top officers are not available. Also, membership of top civil servants on statutory bodies, quangos, GLCs, creates the problem of bureaucratization of statutory bodies and their reduction into government departments. Next one, political neutrality. Yes. Appointees are required to observe, all civil servants are required to observe a neutrality and reserve in politics. The principle is that politicians can come and go, but civil servants must remain professional and neutral in the conduct of their office. But I've been told by many civil servants that that's virtually impossible for them to do, because in the last 63 years, except for 2 years, the same party or coalition was in power. So it's not a case of politicians come and go. It's civil servants come and go. Politicians remain forever. So I think in Malaysia things work the other way. So many civil servants have complained that it's very difficult for them to maintain their professionalism. On the other hand, I have to say this, Tan Sri, that I personally know of many civil servants, public servants, who actually, despite all the odds, have taken a stand and have paid the price. Sometimes they have been transferred, they have been mothballed, they have been put in the cold freeze. Sometimes they've been transferred to the Prime Minister's department from the post they were holding somewhere. Some of them have paid the price and some of them have taken a stand. On the other hand, additionally what I wish to say is this. What the civil servant tells the minister in private, we don't really know. Actually, the civil servant may have told the minister, sir, you cannot do this. This is against the law. The civil servant, however, may be told by the minister, look, you can say what you like, I'm going to do what I want to do. But nevertheless, he has done his job. He has done his job by cautioning the minister as to what the law says. Political anonymity is another principle in the public service. Civil servants are not dragged into political debates in Parliament for their acts of commission or omission. Instead, the minister is vicariously responsible to Parliament for the acts of civil servants. Of course, the minister can act against the civil servant in terms of discipline or tata tertib, but the civil servant is not required to answer to the floor in Parliament. That's Article 43, Clause 3, political anonymity. Then protection for official acts. It's a controversial issue of law. If a civil servant is sued for his or her acts, the government stands behind him. But only if the act was in good faith and in the performance of his duty. So if I sue a civil servant for, let us say, tort, the law of wrongs, actually, even if I win the case, he doesn't pay the damages. The damages are paid by the government of the day. So I sue RIMV head, or road transport head. The government will pay. And not only that, the Pejabat Peguam Negara will be defending him in the court. I have to hire my own lawyer, but he will be defended by the lawyer from the AGC. However, as I said earlier, this is only if the civil servant was acting in good faith and in the performance of duty. But I'm sorry to report that whether he was in good faith, whether he was in the performance of his duty and not on a frolic of his own, that is determined by the minister. The minister can tell the court, I hereby certify he was on duty, and so be it. Then the civil servant is protected and the government will stand behind him. May I now move on to slide 19. Sorry, I have to skip a few. Question of control and accountability. Slide 19. That will be 4.1. Yes, thank you. 4.1. Control and accountability. The performance of the Malaysian civil service compares very favorably, in my view, with public services in other Asian and African societies. In many sectors, drastic improvements have taken place, but there is no dearth of criticisms. It is alleged that civil service lacks initiative. That's why quite often some services are transferred to the private sector, or there is a statutory body, or there is a Congo. So lack of initiative. There are too many procedures, too many hierarchies. For example, Tansri, in the universities, if you want to start a new course, it's not as simple as drafting a syllabus, submitting it to our dean or to our Timbalan Naib Chancellor of the university. Oh, the procedures, the hierarchies are so incredible. It takes months and years sometimes actually to introduce a new syllabus, by which time the lecturer either retires or dies. And so the thing is almost given up. There is a problem of lack of one-stop centers. Sometimes actually you have to go to various departments or ministries for the same transaction. And there's the allegation that some civil servants are not so civil. There's a problem of race, religious or political bias. Examples abound in the work, at least that's the perception, in the work of the prosecution services, in the police, Office of the Registrar of Societies, the NRD, National Registration Department. There are lots of allegations of religious, racial or political bias, and I think these need to be tackled. Next one, there is a problem of corruption. Some sectors and services are riddled with delays and corrupt practices. There is a court case, Tan Sri, which says if there is unreasonable delay, that is prima facie suspicion that some greasing of the palm is expected. I don't necessarily think that that is correct, because actually sometimes the delays are simply bureaucratic. Nevertheless, there is a court case which says that delays may be prima facie evidence of corruption. The Institutional Reform Committee of 2018 heard serious complaints against the police, customs, income tax, immigration, judiciary, and many other government departments, and made some recommendations, which I'm afraid the then government did not declassify. So the report of the Institutional Reform Committee was put under the Official Secrets Act. Civil servants often do favors for the private sector in return for lucrative positions in the sector after retirement. Perhaps there should be a rule, most humbly I suggest a rule, barring a civil servant from working for a prohibited period in an industry connected with his official work. I know this is widespread, Tan Sri. Judges will retire from the judiciary and join a legal firm immediately. It leaves a bad impression. I think there should be a gap of a few years before you take up a job. Now, I fully acknowledge that this is a controversial issue, because some people say a retired judge, a retired civil servant has a right to work. Right to work is part of his right to life under the Constitution. How can you stop him from working? Indeed, there is a right, but perhaps not in the industry connected with his official work. He can take up a job not immediately connected with his official work in the immediate period before his retirement. There is the failure of check and balance. The civil servants are supposed to provide a check and balance to their political masters, but the 1MDB, Tabung Haji, EPF, Felda, Mara, Bank Negara, PFI fiascos reflect a serious breakdown of discipline and integrity and indicate politicization of the public services. We heard, for example, in the 1MDB scandal, we heard that the Auditor General's reports were actually edited, and despite the displeasure of the Auditor General, changes were made to his report. So I think the public service leadership of the last decade could be accused of failing the country horribly, though it may be an unfair assessment, because as has been pointed out, public servants often have no choice but to obey their political masters. Next one, 4.9, Islamization policies are overzealously enforced in a society that is multi-religious and multiracial. Many public servants give primacy to fatwas and to the wishes of the deep state over the provisions of the Constitution and the laws. One example would be the Rebin Abdullah case. A man and a woman, Muslim man and a woman, had a relationship. The lady got pregnant and they got married. Sadly for them, the child was born less than 6 months after the marriage. On Islamic law, the child is illegitimate. The parents did not challenge the legitimacy or illegitimate. They never challenged. They just want to register the child under the father's name. The registrar of births and deaths, however, says there is a fatwa from the federal territories that an illegitimate child must carry the name bin Abdullah. But actually under the Births and Registration Act, which is a federal law, it's a federal law, not a state law. It says very clearly, a child can carry his father's name if two conditions are met. First, the father acknowledges. Secondly, the mother has no objection. In this case, those two conditions are met. The child should have been allowed to register. The child should have been given the name of the father. Ultimately, the matter went to the court. At the Court of Appeal level, the court said, this is not a matter of Islamic law. Births, registration of births, registration of deaths is a federal matter. The federal law applies. Like citizenship, federal law applies. I mean, in Islamic law, the entire ummah is one community. But that's not what the citizenship law says. So you have to follow the citizenship law in Article 14 to Article 29. So that was the issue. But ultimately, actually, even the federal court sided with the registrar of societies. Dress codes are often imposed on non-Muslims in a way that actually causes them some grievances. So I think there is this problem of overzealousness. Then there is bureaucratization of all sectors of society. Malaysia is a bureaucratic state in the sense that bureaucratic influence and procedures permeate every sector of our society, including statutory bodies and our personal experience of universities, GLCs. What do I mean? The membership of civil servants on almost all boards of statutory bodies since the 70s. The issuance of extra legal pekelilings. I want to be polite, Tan Sri, use the word extra legal and not illegal. These pekelilings, instructions, orders, directives, many of them actually are in violation of the parent law of the statutory body. They're in violation of the constitution. But they are issued, and within the civil service, the attitude is that the pekeliling or the policy, dasar kementerian, dasar kerajaan, dasar cabinet is actually more important than the undang-undang. Now, that is not what the rule of law says. If there is a law, the law applies to everyone, and a policy cannot override the law. But I'm sorry to mention that in the public services, dasar and pekeliling and arahan are actually given more importance than the actual law. I'll just give one example. Tan Sri, many months ago, there was an instruction from the Minister of Higher Education, instructing. It was a good instruction, but it was not a legal instruction. The instruction was all senates of the universities must allow students to attend Senate meetings. Actually, the power belongs to the Senate under Akta University College University. The Senate has the power to invite or not to invite, or to invite for a particular issue but not for other issues. That's not the power of the minister. But that's the way things done. There is supremacy accorded to policies over laws. There is serious failure to understand the fundamental principles behind the setting up of statutory bodies, public corporations and boards. The whole idea of setting up a badan bar khanun or a corporation is that you want to achieve a balance between social responsibility and flexibility in terms of procedures. May I now go to mechanisms of control? Yes, number 5. I have mentioned about 18 of these, but actually I don't have the time. So I'll just say there are many mechanisms of control, training, legal literacy. On legal literacy, I have to say this with some sadness, and I'm personally affected by it. I'm a student of constitutional law. There is no knowledge of the Constitution within the civil service. The knowledge that is imparted is very, very superficial. This institution exists, this institution exists, that's all. But the rights, the duties, the limits of powers, for example, human rights, I'm afraid there's not enough knowledge of that. So legal literacy is very low. There are internal controls, supervision, planning, programming, budgeting. There are external controls by way of ministerial responsibility to Parliament, judicial review under the doctrine of unconstitutionality, the doctrine of ultra viris, the principles of natural justice. There are remedies, many remedies available in the courts, public interest litigation in some countries. Even though a person who has been wronged doesn't go to the court, others may go to the court on his behalf, on his or her behalf. That's public interest litigation. So I'm just giving an example. Let us say prisoners are being abused or being beaten, tortured. They can't go to the courts. Either they are too poor or they don't know the law. A group of lawyers or law students or social action groups may go to the court and say, we wish to point out to you that in such and such prison, prisoners are being abused. Women are being sexually abused. Please take up the case. That's public interest litigation. Many countries have developed this. In Malaysia, the law is still in its infancy. Auditor General, of course, can issue annual admonitions. I'm sorry to report, Auditor General's admonitions are normally not taken note of. In fact, in some cases, Auditor General's reports are put under the Official Secrets Act, as we found out in the 1MDB fiasco. There's a Bureau Pengaduan Awam. It does good work, but sadly, it is headed by the Chief Secretary to the government. So basically, the administration investigates the administration. What if my complaint is against a really senior civil servant? What if my complaint is against the KSN himself? So who investigates? Who guards the guardians? Who watches the watchmen? I think that's the issue here. So I think we need an independent ombudsman, as in many countries. And there's another important, interesting constitutional issue here, Ansri. I may be the Pengara of the Bureau Pengaduan Awam, federal body. It's a federal body. I want to investigate maladministration in a state service. The state may well say, hello, who are you? You are a federal body. What right do you have to demand files from the state government? So I think there's this problem of federal-state relations. How can a federal administrative body, not even a legal body, administrative body, examine the confidential documents of the state governments? Freedom of information would be a very important safeguard against corruption or abuse of power. Sadly, we suffer from the Sulit syndrome. Our culture is actually that everything is secret unless it is released officially. Not that everything is open unless put under Official Secrets Act. Everything is secret unless it has been officially released. So we don't have a Freedom of Information Act. Yes, yes, indeed. There could be a commission of inquiry. Sadly, its reports are often made secret. There's a Government Proceedings Act. The government can be sued both in contract and torts by citizens, by public servants. There are such extra-legal checks as service centers run by political parties and letters to the editor column. In my humble view, Tansri, a person with a complaint is like a person with a pain. Doesn't matter how the pain goes away, whether it's in a court of law, whether it is before the Bureau Pengaduan Awam, or in a letter to the editor column. I remember many years ago, one of our first, perhaps our first Director General here, Tan Sri Nordin Sopi. Was he the first one? Tan Sri Nordin Sopi. Yes. When Tan Sri Nordin Sopi was group editor of the NST, he started in the NST a column, a column whereby actually citizens could complain about a government department, and there would be one whole page. On one side is the complaint, on the other side is the answer. I think the press can play a real role in solving grievances very effectively indeed. May I also caution all top civil servants. The tide of international law is lapping at our shores. In some areas, like treatment of prisoners, treatment of illegal immigrants, treatment of minorities, etc., international law is beginning to make itself felt. In your own land, you are as powerful as you can be. But please be careful. you may have a home in New York City, or you may be going on a trip to New York City. There may be a warrant of arrest waiting for you. Please be careful. I understand that in Indonesia this happened. Some of the generals, during the Suharto days, some of the generals had properties in the USA. Their properties were actually attached because people sued them for violation of human rights in the USA. The concept is emerging, Tansri. Some crimes, international crimes, are crimes anywhere, though committed elsewhere. It may be committed in Indonesia, but it could be a crime tribal in the United States. So top civil servants, please be cautious that the tide of international law is reaching us. There may be constitutional commissions and councils. Then I go to number 6, substantive safeguards for public servants. All public servants enjoy some rights and privileges. Next one, 6.2. This is controversial. Actually, there is an Article 136, Tansri, not well known. It says, all persons of whatever race in the same grade in the service of the Federation shall be treated impartially. There is also an Article 153, which allows the Yang di Pertonagong to impose proportions or quotas in the interest of Malays and the natives of Sabah Sarawak. So how do we reconcile 153, which allows quotas and reservations, and 136, which says no discrimination on grounds of race? Tun Sufyan, our Lord President in the 70s, already answered this question in his book. He says, at entry point, quotas and reservations are permitted by 153 as part of affirmative action. But once a person is in the civil service, meritocracy must apply. There should be no discrimination on grounds of race. I think in this area, the senior civil servants must look up Article 136 more carefully and reconcile it better with Article 153. Next one, in addition to Article 136, there is Article 8 on equality and non-discrimination, which should also protect civil servants. And in this area, I have to say that there is, because of Article 8, there should be no gender inequality. It's quite clear that there is gender inequality in terms of top posts. In numbers, yes, women are doing very well, in numbers. But when it comes to top posts, I think there is still gender inequality, and that is a violation of Article 8. We have a good case where a trainee teacher was dismissed because she had become pregnant. And she went to the court and she got an order that she cannot be removed as a trainee teacher just because she is pregnant, because Article 8. However, I report to you with regret, Tansri, that Article 8, equality before the law and non-discrimination, especially on gender grounds, does not apply in the private sector or in GLCs or in Congos. We have a very sad case, Beatrice Fernandez, an air hostess in Mas. She was sacked because she got pregnant. The reason for the sacking was that there's a collective agreement that an employee with Mas, a lady, can take only 1 or 2, I'm not so sure, maternity leaves. Now, she's going beyond that. But she said, but what about Article 8, equality before the law? And the federal court held, sadly, the federal court held in a decision that I strongly oppose. Federal court held that Article 8 protects only public service employment, doesn't protect employment in the private sector. Now, in my view, there are 2 things that are wrong with this Beatrice Fernandez case. First of all, to say that Mas is private sector requires some imagination. Mas, all the top officers are appointed by the government. Mass periodically receives money from the government. Surely there is a strong public element in mass. Secondly, the idea that the perlembagans shield and shade apply only in the private sector, in my view, is totally wrong. For example, could I, in my house, resort to slavery? Slavery is banned by Article 6. Could I, in my house, have a domestic servant and treat her like a slave, no pay? Surely I cannot. By the way, answering, in some countries like India, daughters have sued their fathers for the writ of habeas corpus because the father won't let the adult daughter go and get married to someone who the daughter wants, but the parents don't like. But the daughter says, I'm an adult. I have personal liberty. You cannot prevent me from leaving the house and getting married to someone of my choice. So the idea that the Constitution and its safeguards of fundamental rights apply only in the public sector is a terrible, in my view, shameful error of jurisprudence. Pensions, gratuities and other allowances are protected by Article 147, which provides that the terms of pension can be enhanced but cannot be less favorable than on the relevant date. And I'm quite surprised to note the relevant date is not the date on which you become pensionable. The relevant date is the date on which you join the service. So if I join the service today, then the pension terms in the years to come can be enhanced, cannot be made lesser than what they exist today. That's Article 147. Recovery of arrears from the government is possible. Civil servants are allowed to sue the government in tort. So if, God forbid, the roof falls on a civil servant's head or the stairs are slippery, or the government can be made liable in torts like a private person for occupier's liability. And there must be proportionality in punishment, Ansari. So in Tan Tek Seng, a school headmaster had delayed the payment of the salary of a gardener, had held on to it. So he was found guilty of improper conduct, but he was dismissed. He was dismissed. The Court of Appeal held that while he is definitely guilty of impropriety, the punishment was excessive. Punishment must be proportionate. And the Court of Appeal found the principle of proportionality as a consequence of Article 8, equality before the law. Equality before the law means that all persons who are convicted of wrongdoing in the public service must be treated fairly and proportionally. So administrative law is developing quite well. Then there are procedural safeguards under Article 135, Clause 1. One procedural safeguard is under Article 135, Clause 1, that the dismissing authority must not be inferior to the appointing authority. So if I was appointed by the Police Force Commission, then the dismissal cannot come by the IGP. It must come from either the commission or someone superior. Now that was the law in 1957, Tansri. I'm sorry to report to you that since 1957, several amendments have been made, and now actually delegation is possible. I am quite sad to report that Article 135, dealing with safeguards for public servants, is one of the most amended articles of our Parliament. So the government has lost a lot of cases in the civil courts, and once it lost the case in the courts, it went back to Parliament, amended the Constitution, backdated the amendment to win back in Parliament what it lost in the courts. So someone jokingly told me, a student told me, whenever the government loses a case involving civil servants, then the empire strikes back. An amendment is made to the Constitution. The return, yes, like in Star Wars, the return of, yes. So there are a lot of exceptions now to 135 clause 1. Let me go on to number 8, 135 clause 2. 135 clause 2 says that no public servant shall be dismissed or reduced in rank without being given a reasonable opportunity of being heard. Tan Sri, I could write a thesis on the word dismissal, or on the word reduction in rank, or on the word opportunity of being heard. These are words loaded with meaning, rich meaning. Basically, what it means is this: 135 clause 2 is a beautiful rule of natural justice in administrative law. Odi alterum partem, no one should be condemned unheard. You can punish someone who has done wrong by hear him out first. Basically, that's the rule, and I think that's a very good rule. Hearing means that a servant should have a full and fair opportunity of stating his case. He should be supplied all the incriminating evidence, information, and documents made known to the adjudicator. However, the exceptions to this rule are legion. So many exceptions, it's incredible. May I go to slide 9, yes. Unfortunately, there are many exceptions to the right to be heard. The safeguards of Article 135 Clause 2 do not apply to members of the armed forces. They can be dismissed without a hearing. Now, as a student of law, Tan Sri, I object to that. We are not saying they should not be dismissed, they should not be disciplined, they should be, but they should be heard. They should have a right to be heard because there may be a false allegation. Nevertheless, 135 clause 2 doesn't apply to members of the armed forces. 9.3, dismissal. Everyone who is dismissed has a right to be heard. But dismissal is treated as different from termination in the public interest. Termination does not require a hearing. Now that's not very fair. If I'm a civil servant, I'm not dismissed, I'm terminated. Actually, for all practical purposes, I've lost my job. When I go back home, I'll tell my family, I have no job tomorrow. Now, whether you call it dismissal or you call it termination in the public interest, it amounts to the same thing. Nevertheless, there is no right to a hearing if the government says it's dismissal in the public interest. Then reversion to former post does not mean reduction in rank. You may be the dean of the faculty today, tomorrow you may be sent back actually to an ordinary lecturer's job. That's not reduction in rank, that's a reversion to former post. Now, I can understand if a person was appointed for 3 years and at the end of 3 years he's told, thank you very much for the good job you have done. But if after 3 months he's sent back, I think he should have a right to be told why he's being terminated prematurely. I think there should be a right to be heard. So, right to be heard does not take away the power of the university to remove a dean, but there should be some chance to explain why the term is being reduced. There is no need to give a hearing prior to dismissal or reduction in rank where a criminal charge has been proved. Next one, there's no need to give a hearing where the authority is satisfied that hearing is not reasonably practicable. What does this mean? It basically means any time the government wants, it can issue a certificate that hearing is not reasonably practicable, so no need to give a hearing. 9.7, there's no need to give a hearing if the Yang di Pertonagong says that in the interest of the security of the Federation, hearing need not be given. 9.8, there is no need to give a hearing if the civil servant was suffering an order of detention, supervision, banishment, deportation, or restricted residence. Also, I'm sorry to report 9.9, the safeguards of Article 135, Clause 1 and Clause 2, especially Clause 2, the right to a hearing, applies only to dismissal or reduction in rank. but not to other ways that you can deal with civil servants. I've listed out 15 other ways in which you can deal with civil servants where the safeguards of 135 clause 1 and clause 2 do not apply. What are these? May I go to 9.12? There are 15 measures other than dismissal or reduction. Interdiction. Interdiction is that you are suspended but on salary or reduced salary. But you do get a salary. It could be full salary or reduced salary. Suspension. Suspension is on no salary. Termination under contract. Termination in the public interest. Reversion to former post. Lateral or horizontal transfer. So today I'm in Kuala Lumpur. Tomorrow I could be told that I'm going to Tawau on a transfer. Now, for all practical purposes, it will put my life totally topsy-turvy. But there's no need to give a hearing. No need to say, show cause why you should not be transferred to Sabah. So then if there is detention, supervision or banishment, administrative detention, there's no need to give a hearing. If institution of criminal proceedings, there's no need to give a hearing. Compulsory premature retirement on medical grounds. There's no need to give a prior hearing. So says the 1993 rules. But there is one case, Tansri, where the courts have said, no, if you board someone out on medical grounds, then your medical board's opinion must be made available to the officer concerned, and his doctors must be allowed to examine it. So here the courts have mitigated the harshness of the law. Surcharge, on the other hand, has a right to a hearing. Reduction of salary has a right to a hearing. Deferment of salary movement has a right to a hearing. So now I am a little bit surprised, and I want to point out the law is inconsistent. For termination in the public interest, there is no right to a hearing. But for the small punishment of amaran, warning, I have a right to a hearing. So that's very funny. Out of these 15 ways of dealing with public servants, for some serious punishments, no hearing is allowed. Because these are punishments not covered by 135 clause 1 or clause 2. But for things like fine, warning, forfeiture of emoluments, is a right to a hearing. So the law is a little bit inconsistent, and I think we need to rationalize the law. We need to rationalize the law for two reasons. May I go to slide number 52, that is 9.15. Yes, 9.15. There are two reasons why we need to give a hearing across the board, not only for some types of wrongs and not for others. First of all, the requirement of equality before the law in Article 8 of the Perlembagaan. Everyone should be treated equally. So a person who is to be fined should be treated no more favorably than someone who is to be terminated in the public interest. And secondly, the natural justice requirement of odi alteram partem, hearing. Tansri, it used to be regarded as a rule of common law, as a rule made by judges. But now some of our learned judges are saying natural justice is not just common law. Natural justice is part of the Perlembagaan in Article 5, due process. So if it is due process of the Perlembagaan, then you can't take it away. Now may I go to the last part of my presentation, problems and challenges, the size of the public service and the total emolument. It is believed that the civil service is bloated. In March 2019, we had 1.71 million public servants. Now, I wish to clarify here, this 1.71 may be an unfair number, because in many other countries, Ansri, the numbers of the public services exclude army, police, and health and teaching. But in this country, actually, all these are lumped together. So 1.71 is perhaps not the correct number, because we are including nurses and teachers and army and police soldiers, yes. They should be regarded separately. Yes. Yeah, yes, that's right. That's right. Bloated. That's why it is so bloated. But actually, in real practice, it's not so bloated. Anyway, the total annual emolument of the public services is about 82, and there's no mistake there. It's 82 billion, not 82 million. And it covers 5.1% of the GDP. The salary gap I pointed out earlier between the top and the bottom hierarchy is very large, and I think there should be some reduction there. I'm not saying that there should be equal salary for everyone from the KSU to the garbage collector. I'm not saying that at all, but nevertheless, I think these disparities need to be reduced, because those who need the most get the least. Those who need the least get the most. And I think there's a little bit of a problem there from the point of view of social justice. So if an office boy wants a loan, transport loan, his entitlement is obviously much lower, whereas those who already have much big salary have much. I know they say ability to pay, but nevertheless the point is this: the gap is very wide. Mandatory retirement age. Now, I know some of you will be amused by this. With improved national health, the mandatory retirement age of 60 may not be suitable, fair and just. In many countries, it's 65. And by the way, in some countries, Tansri, a mandatory retirement age is a violation of equality before the law, because you are discriminating on grounds of age only, not age plus a calculus of other factors. So some people say it should not be age. If a 60-year-old is productive, healthy, productive, willing, and a 45-year-old is not so healthy, not so productive, why should the 60-year-old be put to pasture, if I may put it that way? And the 45-year-old still continue to serve for another 15 years. So there should be a calculus of factors, including calendar age, medical age. Medical age is different from a chronological or calendar age, health, productivity, etc. And this next point is even more controversial. Why do politicians and MPs have no retirement age, Tansri? You can be Prime Minister at age 93 also, but you cannot be a civil servant after a particular age. If judges can work till 66 and a half, and the judicial work is very heavy, the amount of reading and writing they have to do is incredible. If judges can work till 66 and a half, why not public servants? I think there is an issue of Article 8, equality before the law in different age of retirement, or no age of retirement for some and age of retirement for others. Pensions. Can the economy of the future sustain the multi-billion, not multi-million, multi-billion and growing pension budget? There are nearly 874,000 pensioners, and it takes 27.1 billion, not million, billion, or 1.7% of the GDP to meet their pension right. Now, due to the guarantee in Article 147, pension and gratuity entitlements can be enhanced but cannot be reduced. This means that those who have already retired or those who have already joined the public service cannot be adversely affected by any change in the law. Even if you change the law, you cannot adversely affect them because Article 147 says so. So what can be done to reduce the government's unbearable pension liability if the government, for economic reasons, needs to do that? I've divided that into 3 or 4 areas. Number one, in relation to those who are already retired. Number one, not much can be done. Why? Because the Constitution in 147 says, once you have joined the service, the terms can never be reduced. They can be enhanced, not reduced. However, one could amend the Parlembagaan to reduce or abolish pensions. We'll have to amend Article 147 and we'll have to backdate it, Tansri. we'll have to backdate it. Some of you may say, can law be backdated? Yes. Criminal law creating offenses cannot be backdated. Civil law, and pension law is a civil law, can be backdated. But it will require a 2/3 majority. And the government doesn't have 2/3 majority. Don't be scared, the government doesn't have a 2/3 majority. Also, please bear in mind, no government will do this, because this will have disastrous political consequences. There are 874,000 pensioners and their families. And there are, yes, and there are 1.71 million public servants and their wives and husbands and children. This would be suicidal politically. So that's the position for those who have already retired and already joined the public service. Very drastically, one could employ Article 150 emergency to declare an economic emergency. And see, emergency doesn't only mean riots and war. Emergency can include economic emergency. Emergency could be declared under 150, and Article 147 can be suspended. However, it can be suspended only during the emergency. Once emergency ends, Article 147 comes back to life. I know Puan Sohana is getting worried a little bit. Don't be worried, don't be worried. 147 can be suspended, but only during the emergency. Yes, yes. Now I come to those who are already serving, who are already joined the service. Without amending the constitution, the government could switch to an EPF type of social security scheme in which all public employees as well as government contribute monthly to the fund. Now, the government will have to ensure that this is an attractive alternative optional scheme, and the government can offer an option to the civil servants. Article 147 clause 3 has a provision, Tansri, that where the law applicable to an award depends on the option of the person to whom it is made, then it is presumed that that option is more favorable than what was existing at the time he joined. So at the time I joined, there was a particular law. Then they gave me an option. If I take the option, that's it. Option will be regarded as more favorable. So I think...
Sorry, question answered.
Okay.
If there's not nobody asking, then we continue.
Sure. Right. Yeah. Okay. So, sure. Okay. Thank you very much. Thank you. Yeah. Right. Thank you so much.
May I invite some comments or questions from the members?
Yeah, we have a few listed already.
Okay.
Just as a quick reminder, you guys can still actually, you guys can still ask questions. You can either have them typed in the Q&A box. As you can see, we have 4 at the moment. You can do that while we're going, or you can raise your hand so we can ask. You can ask your questions verbally to Professor Shad. So far, we'll ask the first one, I think, because...
We did 2 questions first.
Yeah, exactly. It's by the same person too. We have Shakti, who's asked 2 questions. I think they're quite connected in a sense. They asked, may I know how often does the Agong step into matters of civil servants? Is this publicly accessible, or is it under the Official Secrets Act?
How far does the Agong?
How often does the Agong step into matters of the civil service, civil servants? And there was a similar, and they've also added another question that and on the Official Secrets Act, how impactful is it towards reform within the public service?
Okay. Yeah. Right, I can answer both of them quickly. As far as I know, the Yang di Pertuan Agong does not step into matters of public service. I think he acts on advice. The Agong appointments are made in his name, but actually it's basically a decision of the government. We have to please remember, we have a constitutional monarchy and not an absolute monarchy. Top civil servants are basically appointed by, on the advice of the Prime Minister or of the KSN or KSU. And it may be done in the name the young Di Pertuanagong, but I don't think he steps into the matters at all. Then as far as OSA, how impactful it is, that's a very nice way of putting it. Actually, it's impactful towards preventing accountability, not creating accountability. OSA is justified in such matters as national security, diplomatic correspondence, and other such matters. But I personally think our OSA should be amended to have what could be called a public interest defense. So if I'm prosecuted for breach of the Official Secrets Act, I should be allowed to tell the courts what I did in the public interest. And if I can prove that, then it should be a defense. Like in the law of defamation, Tan Sri, I say something bad about someone. He sues me in defamation. I have the defense of qualified privilege. I have the defense that actually what I did was in the public interest. So there should be a public interest defense. The OSA is one of the biggest hurdles to enforcing accountability, openness in government.
Thank you. Next question.
Yeah, we have another one. This one's from Sarah Hamza. They ask, in your opinion, should a public officer be allowed to participate in politics?
The way the law stands today is senior public officers must show reserve, but the lower you go, the more freedom there is. The lower ranking officers actually can take part in politics, but senior officers must remain neutral. That's the way the law is. And personally speaking, I support that law because actually, please bear this in mind, we are a country with a supreme constitution, a right to association. Opposition parties are allowed. If I'm dealing with a director general or a KSU who belongs to a particular party and is an office bearer there, there will be a feeling that maybe my application may not be considered impartially. So I think justice must not only be done, but must be seen to be done. So I think senior civil servants certainly should not be holders of public office, should not be holders of political office. But of course, they have a right to vote, like any other citizen, but not holders of political posts. Or in their conduct, they should not be very, very open in siding with political parties, going and behaving in a very partisan manner at functions of political parties. They should not do that. But I suppose if in the lower rungs of the civil service, not in a position to make an impact on people's rights or duties, then I suppose there's no harm in being a member of a political party.
Yeah, just a heads up, this is going to be quite a heavy question, partly because it's quite long. From Tengku Ahmad Hazri, they asked, the Constitution explicitly excludes members of the administration from its definition of public service. Yet, as can be seen from last year's federal court ruling in Tony Pua's public misfeasance suit against the government, the Prime Minister could still qualify as a public servant. And so it could establish liability. So what explains this dual standard? Given the need for government accountability to the public, what then does the Constitution seek to accomplish by the technical distinction between the government and the public service?
Yes, actually that's an excellent question, and it helps me to highlight a very important decision. Now, under the Constitution, Article 132, just give me a minute, I'm trying to find my pages here. Under Article 132, the definition of a public service is given, and it clearly excludes ministers, deputy ministers, judges, members of commissions, and rightly so. They are not public servants. But Article 132 is carefully phrased on this point. It says, for the purposes of this Constitution, the public services are the armed forces, the judicial legal service, the general public service, the police force, joint public services, public service of each state, the education service. That's all. Nobody else is part of the public service for the purposes of this Constitution. So, for purposes of appointment, promotion, tata tartib, that is discipline. Even statutory bodies are not public servants. I'm not a public servant. I'm not a public servant. I'm the servant of a statutory body. Ministers, deputy ministers are not public servants. But for purposes of the law of torts, the law of damages, for purposes of the law of crime, they are public officers. So I think that's what initially at the High Court and Court of Appeal level, it was held that the Prime Minister is not a public officer. They didn't use the word public servant, he's not a public official. But then ultimately the Federal Court held, and I would say correctly, it's an excellent decision, that only for the narrow purposes of appointment, promotion, discipline, is he not a public officer. Otherwise, he is a public official. And I think that's the way it should be. I mean, if the Prime Minister is not a public official, what is he? Is he a private official? He's not surely the Prime Minister is the supreme public official. Yes. Yeah. Even in the, let us say, University Colleges Act, we are, university servants are not public servants, but it says very clearly, but they are public officers for purposes of the criminal law. So it depends on which purpose. So thank you so much, Tunku, for this question. I think the Prime Minister is not a public servant, but he's a public official for criminal law purposes, the law of tort purposes, and the law of contract purposes.
Thank you. Yeah, actually, they're getting really active now. We're getting lots of questions now. Yeah. So another one by Shakti, it was voted up as well. They asked, how does the Whistleblower Act work in practice in regards to civil service reform?
Which law?
The Whistleblower Act.
Oh. Yeah, sure. Actually, the Whistleblowers Act was a good beginning. I want to be positive. It protects public servants who blow the whistle, expose wrongdoing. But it has one great defect, and that is this. We are not allowed to blow the whistle except to those in the hierarchy. So, if I'm a member of a university and I see wrongdoing in the university, I can blow the whistle to officers of the university, or I can blow the whistle to the Anti-Corruption Commission. But if I report to the MP, then I'm violating the Official Secrets Act. So the problem here is this. Sometimes people are scared to report their superior officers because actually their promotion, their job is dependent on their superior officers. So the main defect of the Whistleblowers Act is that the requirement of only reporting within the hierarchy is something that dissuades people from sticking their neck out.
Actually, there's another question as well by, sorry, let me just scroll to this, by Yik Kunte. Was on the similar line of not speaking out against, on universities as well, coincidentally. So they asked, when we came across gross wrongdoings, we complained right up to the VC and board, and to the board of directors, but no action was taken. We were warned not to write to the ministry. So what can those who have spoken out but were victimized do to, what can we do when when the victimized are examples to others not to question the authority?
Yeah, I think it's similar to what I said earlier. Sadly, the law at the moment allows us to blow the whistle, but only to we can only raise the information with our superiors or with those authorities like the anti-corruption agency or the police, but there's really no safeguard if those in authority then victimize you for having blown the whistle. At the moment, the law is inadequate. We just have to wait and see. The Whistleblowers Act could be improved in the years to come on the patterns of the laws of many other countries.
We have a question from Arif Abdullah asking about what do you think about having a Freedom of Information Act instead of the OSA for more transparency and appropriate public accessibility? Because since the OSA can easily can be manipulated, such as to prevent public access or accountability.
Sure, I think that would be the best thing that could happen to the country. Having a Freedom of Information Act does not mean that everything will enter the public domain. There will still be exceptions on grounds of national security, public order. For example, police investigation papers will never be made public. There will be protection for whistleblowers. I think having a Freedom of Information Act would solve a lot of problems. Even the earlier questions about whistleblowers, I think that problem, whistleblowers' problem is Official Secrets Act. And I think if there is an Official Information Act or Freedom of Information Act, where persons can go to the court. By the way, in some countries, you can't just go to the department, fill a form and pay a fee and obtain the information. You have to justify it. And if the department refuses, the courts decide. Courts decide whether the refusal is justified or not. So yes, indeed, a Freedom of Information Act would be the best thing that could happen to this country with necessary safeguards and restraints.
Okay, ignoring that.
Did I say something wrong?
Okay, that's fine. There's on the topic of pensions, Amirul Amri Hasnul asked, what's your opinion about abolishing pensions to the politicians instead of the civil servants?
Well, I already covered this issue that for civil servants, the pensions are definitely the law, or maybe I didn't get to cover it in detail. The law relating to pensions of politicians is very unfair in their favor, in the sense that you and I have to work minimum 10 years, reach a particular age, and then only we get the pension on a particular formula, last drawn salary multiplied by 0.00 multiplied by this. When it comes to politicians, they don't have to serve minimum 10 years. They don't have to wait till the retirement age. And they don't have to even serve as, actually, even one full term is not necessary. I understand it's, I think, 3 years. As long as they have served 3 years of their term, they qualify. And the most scandalous thing is, money-wise, multiple pensions are available. Tansri, I understand that tax is available, tax is imposed only on one. Tax-free is only one. The rest are subject to tax, but multiple pensions are available. Someone is an MP, that's one. Someone is a minister, that's two. Someone was Katua Mantri of a state, that's three. Someone was a assemblyman, that's four. And maybe before that, someone was a judge, that's five.
During the IMSAM, Minister of Finance, you just create the highest It's completely.
I'll check on
not
that.
paid.
My impression is that multiple
During
pensions are
during
available.
85-86 crisis.
I see. Okay,
Just
I'll
paid.
check on that.
It was a case of Datuk Asri, Menteri Besar Kelantan.
Oh, yes,
He was
yes.
the Minister of Rural, Regional Development, the Minister Besar, as parliamentarian. I think just say only give the highest, and that's it. It's not paid. So
If that is so, that would be very good.
100%, so to speak. Something like that.
That would be very good. But what is certain is that they don't have to do 10 years, they don't have to wait. So in that respect, the law is very much in their favor. They made the law for themselves, and therefore it is so favorable to them.
Yeah. True.
Yeah, questions of pension has been starting to pop up as well now. On the topic of pension liability this time. So Rajni asked, for the long run, the easier option is to offer a contributory scheme to new joinees. Is that politically feasible, or perhaps much more than for those who have already retired or currently are in service? Because that talks as well about
Yeah,
like
and
KWS.
actually, as I didn't get to finish this, those who have already joined the service, the only way to affect them is to offer them an option. Otherwise, they are protected by 147. You cannot take away, you cannot reduce, but you can offer them an option. But those who are not in service yet, maybe there should be no more pensions for them. Maybe from the day one, they should be on an EPF type of scheme.
I remember during 85-86 crisis when Daim Zainuddin was Minister of Finance, and he was saying that whether you can opt for EPF. Then the GP advises, I was then Minister of Finance, I was then in the Treasury, because shouldn't have two treatment to civil servant. You give one pension, everybody else get pension. Something like that. Unless they opt for EPF in the beginning of the service. That is allowed. So the choice is made when on the point of joining the service. Having joined EPF, pension or the pension scheme, you cannot be doing. I'm standing to be corrected here.
Yeah. No, that's it. To me, the main, I may be wrong here, the main issue of pension is that the civil servant is not contributing anymore. Initial years he's contributing, and then once he becomes pensionable, only the government is putting in the fund. Whereas in EPF, both sides are contributing, and it's a bigger sum.
The other interesting point on this share is this. You have got people who have retired very high position, like Secretary General or the Chief Secretary, but the salary then was very low. So you get 3,000 ringgit, 2,000 ringgit is full pension now. He retired in 70s, he's still alive in 2020. He's pension about 2,000 ringgit, but now it's junior officer retired 5,000, 6,000 pension. So normally, I wrote this article in the Straits Times one day. I called it temporal inequitable treatment, something like that, over time. I remember, from Hashim Aman, was getting 4,000 ringgit. Then 50% of 8,000 was very high in the 70s.
In the 70s.
But in 2020, 8,000 is nothing, and it's 4,000 is nothing. My pension even higher than him. I never reach a KSN anyway. Something that, and now my junior getting more than me. So a group of lawyers and judges took up this case. There is a provision in the law, in the constitution, said that if you review a salary, you must review the pension. Now, if you adjust the salary, you adjust the pension. If you review salary, they go along in tandem. So it's something that we got to check. Some lawyers have looked into this, and there's something that the government did not practice, and there may be a case against the government. Just to share with this.
If I may just go back to that issue of whether there should be a mutually contributory scheme, I support that strongly, because I think every humane, civilized state must take care of those who are aged, who are disabled, who are marginalized. Let's not forget that not every civil servant ends up being in category A. A lot of them actually, the bulk of them actually are in lower categories. And once they have retired, they don't have many means of income, or any means of income, many of them don't. So I think a social security scheme is a good idea. May I please remind you, Roosevelt tried to do that in the USA in the 30s, for which he was severely criticized. but nevertheless he insisted. He was a good leader. So I certainly think there should be a social security scheme. It's a form of forced saving, EPF. The only problem of EPF is this, that many people will retire, collect a few $100,000, and within 3 years they spend it. I'm told that it takes 3 years. 3 years to wipe away your EPF. Men will go around, get married again, and they will spend a lot of money on things which were unnecessary. So we need to adjust that, but there surely should be some scheme for social welfare for those who have retired, especially with our health scheme having improved and people now having greater longevity. Yes, indeed.
Because of the aging population, people actually at 70, 80 years is easily now better medical treatment, health services. They must be taken care of.
There could be alternative pension schemes maybe that could merge. As the answer said, we need to review this. Surely there should be some social welfare scheme, but whether it is EPF or whether it is pension or whether it is insurance, that's a matter of working things out.
Any question, Isa?
Yeah, it's actually a very good segue on the topic of health now, because the next question is actually asking about healthcare officers. Kevin Ng was asking that normally these officers are omitted from calculations of civil servants, but this isn't the case in Malaysia. So with the current experiment of hiring the majority of junior healthcare workers under short-term contracts, and given the increasing needs of healthcare in this country, would the lack of long-term contracts of healthcare workers be a violation of their rights to serve, as well as a disservice to the people?
Basically, the issue is this, that people have a right to work in the government service. At the moment, there is no such right, but I can see the emerging issue. Right to work, is that part of life? Life to include necessities of life. So these workers were basically on, if they were on scholarship, they are forced to serve. And sometimes I know they want to serve, they are not placed. They are waiting to be placed. And in the meantime, they end up selling burgers or doing very humble things. So surely, I think in this situation, the government should be a little bit more flexible. So if a job cannot be found within a few months, 3 months, let us say, or 6 months, I think they should be released. But if the question is, do people have a right to work? Then I have to say I'm afraid this is an impossible proposition, because right to work would involve that there must be vacancies. Then the government will have to keep on, every year they'll have to keep on increasing by hundreds of thousands number of jobs. It's an unworkable proposition. I think all that we can require is equal treatment. And I want to say this, health workers, the word actually is very broad, health workers, but let me just talk about dentists and doctors. They are forced to do compulsory government service. Lawyers are not required to do compulsory government service. I think that's a violation of equality before the law. Engineers are not required to do compulsory government service. Why not? If the rule is that because we spend so much money on your education, then I think in all technical professional services or in services which the minister has declared to be essential services, everyone should be subject to compulsory medical service. Compulsory government service for a few years. So I agree that there are issues of equality before the law. But if you're saying there is a right to work, that is difficult from the point of view of enforceability. Another issue of equality is this. In some services, like in the armed forces, there are beautiful schemes for compensating those who get injured or who die in the course of their duty. I think we should have a similar scheme for our frontliners. I think this nation owes them a great deal.
Indeed.
They actually went through, for our sake, they went through hell. And they are not eligible for the kind of special schemes that exist for the armed forces and for the police.
Prof, may I ask you, you mentioned in your presentation the role of ombudsman. Ombudsman because you want to check the efficiency
Yes,
of the
yes.
government. Yeah? You may want to elaborate further. What do you mean by ombudsman? How can it be contributory to the better efficiency of the public service? I know it's available in Norway or Sweden.
In many countries, they are called by many names. In India, they call it Lokpal. In the UK, Lokpal, Lok is the people, the friend of the people. In the UK, they call it Parliamentary Commissioner of Administration. In the UK, they have a separate ombudsman for health, separate ombudsman for police, separate, they call it by different names. Oh, I think it's a very good idea, Tansri, because the courts are an remedy providing institution, but they should not be the only one. As I was saying jokingly, a person with a complaint is like a person with a pain. As long as my pain is gone, doesn't matter whether it's a surgeon or a bomo or a sensei, as long as my neck pain is gone, I'm happy. So whether it is a letter to the editor or an ombudsman, or in Islam they will say muhtasib, doing the system of hisbah. As long as my complaint is solved, I think it's a good idea. I didn't get to mention that, but Tansri Nordin Sopi, he did a beautiful job in the Straight Times. At that time, Straight Times was a broadsheet. Half the page has complaints, half the page has answers from the government servant. And I thought that was beautiful.
That can be done because
It
we
can
have
be
the Public Complaints Bureau.
Yes.
They've got a lot of things and efficiency in the government. You can say, these are the complaints today, or whatever, and then these are replies from the other side. Because they got the replies anyway. Just make it public.
Sure.
I think that can be done.
For a long time, the Public Complaints Bureau was keeping its reports under OSA, confidential. I know many of my students went to work, so they gave statistics, but they say, I can just tell you unofficially, but I cannot give you the documents because it's OSA, which is unnecessary.
Let me use my position as a chairman, which I'm privileged this afternoon. You mentioned something that because of the lack of initiative of the government servant, therefore government privatized the agencies. It may not be true.
It may not be true.
The reason being this, previously the government provide telecom services and Tenaga Nasional, that sort of thing, because they are considered public utilities, Yes. And by definition they are monopolies. But now we can break telecom into handphone.
Yes.
So we can carry around that sort of thing. It's so handy. You don't need government big investments anymore. Therefore you can privatize it. All set standards. We have a commission, the MCMC set standards, and therefore you can buy from the shop. So you privatize the sort of things available. So it's water now. Water, you can get private sector to sell, treated water, bottled water, sort of thing. So there is a supply and demand that you can price it.
Yes.
So I think that's why it's privatized. It's not because initiative and that sort of thing. In fact, this started from UK and during the days of Margaret Thatcher.
Oh, yes.
That sort of thing. It is not new. In the 80s. Some people call her my great teacher, and not Margaret Thatcher. These are among the things to share with you. The other thing you mentioned was the definition of civil service and public servant. In Malaysia, our definition of civil public service takes in the army and the police.
Yes.
So I don't know how many we have, but certainly in the region about 150 to 200,000 in balance.
I think 100.
And in the Air Force, the Navy, the military, that sort of thing, plus the maritime sort of thing, enforcement. So that's why I think it's quite big. And the other one with definition of, we also bring, the problem is that we have teachers and health staff.
Yes.
We talk 1.5 million.
Yes.
Total employment in the country is about 14 million. 1.5 over 14 million, hardly 10%. So it's small. The rest 90% private sector or self-employment. It's not very true. That's number one. Number two is that the largest part of our civil servant is the teachers. About 470,000 of them.
Yes.
Almost a third. And next one is health staff, medical staff, another about almost 300,000. So combined these two is about 800,000. It's almost 50%. And
Yes.
because of our increasing population, birth rate, that sort of thing, especially in rural areas, therefore we need more teachers. And now the preschool has become part of the education service, so automatically they get more and more teachers, that sort of thing. And that's what we have. And then the other thing is the definition of public also include state government and local government. So it is, so it's big. So to compare, apple for apple, they may not be comparable. That's all. Just to share with you the definition. Thank you very much. I think that's my comment. Any other more, Poeza?
There's quite a few, but I think
In the interest of time,
wait,
I think
should
we have
we?
finished by 4. We have finished by 4. Oh, is that? Can we, time is limited, no? Boleh lagi? Tak ada lagi? Dah habis?
I think we can wrap up. Maybe it's like in the
Yeah,
interest of time.
maybe I give you the last say with something,
Yeah,
1
if
minute.
there's any.
You are.
So thank you.
Thank you.
I'll be happy to answer any more questions, but if time is up,
Yeah,
I think
in the
next time.
interest of time. Yeah, no,
Next time.
I'm very sure there's plenty.
So, I mean, it's very interesting presentation, Prof. I think it opens a lot of issues that we can, certainly for public administration students, very good. Certainly civil servants who are in the public services should have, should listen to this sort of thing, where they can improve the civil service. Not so much to be critical per se, but to improve the civil service. That is our aim. Thank you very much, Prof. Thank you very much. Thank you. Thank you. Bye. Bye for all the participants. Thank you very much.